To unpack the proceedings, we're joined by legal analyst advocate Mpilontle Baloyi. Advocate Baloyi, good afternoon. Thank you so much for your time. Really do appreciate it. Negligence is negligence, whether or not you intend to harm or not. But we don't seem to punish it and sanction it in the same way. Does the defense have make a valid point there in terms of intent to cause harm?
Well, thanks, Oliver, and it's great to be here. As a point of departure, we must acknowledge how much of a tense day yesterday was. There was a great sense of uncertainty as how the day is going to unfold, or how's the day going to end, as to whether the judgment or the sentence was going to be passed yesterday, and we have seen that postponement. And
is it typical for sentencing and pre-sentencing hearings to be postponed?
Yes, it is typical, based on what the court needs to hear and the time frames. So yesterday, for most of the day, was the examination-in-chief, cross-examination and re-examination of the social worker, and properly unpacking that report in light of the case as a whole, as a pre-sentencing procedure. So it's quite possible that perhaps yesterday they could have finished, and we would be sitting here knowing what the future holds, or what is the current state of affairs. But that has to go to mid-April for the finalization, submission of heads of argument, and I think they've set down about 2-3 days, then we'll know. So,
shouldn't they have submitted heads before they appeared yesterday?
No, not necessarily. Remember, the heads also need to encompass the evidence that was heard yesterday.
Right, okay.
Yes.
Okay, and so let's talk about yesterday's evidence. What weight do social workers and social assessment reports hold in sentencing proceedings?
Well, that is a tool of assistance to the magistrate in reaching her.
The magistrate may still choose to disregard it altogether.
Of course, the sentence will still remain the prerogative of the magistrate, but the factors that have been placed by the social worker have to be taken into consideration. So. If you heard that whole evidence, it goes back in time, explaining who the convicted person before court is, so that the sentence may then match this particular person. So it's not a blanket approach of a...
some of it sounded like a character witness by a seemingly objective party, psychologizing Julius Malema, the type of person he is, the role he plays in the community. In one instance, there was a debate about whether or not him being a politician should have any bearing and has any relevance. And it seems as though that the defense at some point said it has relevance, but at another point wanted to argue that it doesn't have relevance. And so there was then a dialectic as well. What entails a complete social worker report for the purposes of the assessment of the court? And does it include a character report?
It includes,
a character assessment, rather.
Of course, it includes almost everything, because what we are debating at this stage, and we must be clear, is whether this is going to be a custodial or non-custodial sentence. And the bulk of that report is moving away from a custodial sentence, trying to show that a non-custodial sentence will be best under the circumstances based on these particular factors of this person. Now, what's important there that we need to draw in is the socio-legal relationship of society, the relationship between the law and society. There seems to be a very wide gap at the moment. We will remember that in 2021, the courts have already shown us that anybody can go to prison. Anyone can go to prison. And South Africans were left mostly baffled about how can a person go to prison when they've never appeared before court. And we saw how 2021 unrest then follow. Now we have an accused who has gone through all the processes
and has been found guilty.
And now we're at the sentencing stage. We want to also see the maturity of the magistrate, or of the bench as a whole, because this does seem to be like a hot potato. Custodial versus non-custodial sentence, when the prescripts of the law are actually quite clear on the minimum sentence, for example.
And in this instance, it's a 15-year sentence, right?
Yes.
But is it a prescribed sentence very specifically custodial or non-custodial, or is that discretionary to the presiding officer?
The only discretion that we've seen, especially on the comparative cases that were listed yesterday, is that there has been instances of deviation from the minimum sentence. But however,
in exceptional circumstances.
Yes, but it was still custodial.
Right.
Instead of the 15 years, it would perhaps be 5 or...
Oh, so the deviation wouldn't be from custodial to non-custodial.
Exactly. So there has not been a case law, and that was also part of the debate yesterday, that there is no case law with facts that mirror the ones of Julius Malema as they are, and a precedent on that particularly. So the implications of the custodial sentence is the political ramifications and what that means for him as an individual, what that means for him as a member of parliament, because already a custodial sentence of longer than 12 months
would expel him.
Yes, would prevent him from being a member of parliament. And there is no case law that already shows that there was a complete deviation from a non-custodial sentence. I mean, from a custodial sentence to a non-custodial one. So it's...
In the absence of case law doesn't mean such a judgment can't be made. They would have to prove on principle that the magistrate has the powers to make that sort of a deviation, and that the facts, or at least the circumstances, support such a deviation. Do you feel that an argument was made, at least yesterday, probably not yet, but that there's an argument that can be made that a magistrate has the power to deviate from a custodial to a non-custodial sentence?
Absolutely. And what we must remember is that is upon what the conviction was based. This conviction was based on evidence beyond reasonable doubt, because that's the standard of proof in the criminal proceedings.
Despite the fact that Julius Malema claimed and maintained that it was a toy gun.
Exactly, but the court still found that beyond reasonable doubt, he's guilty. Now, beyond reasonable doubt is a very high standard, and what comes after it, this sentence, must also be a proper reflection of something found beyond a reasonable doubt. So this cannot, that's where the difficulty or the gap widens between the law as it stands and society and the interests of society.
Yeah. Would Julius Malema have had a better chance at making that argument if he pleaded guilty?
Remember, if he pleads guilty in the beginning of the proceedings, it would have been a matter of that goes straight for sentencing.
Yeah.
And in sentencing...
that would be considered mitigation?
Oh, absolutely. In mitigation, the fact that he did not waste the court's time, the fact that he has shown remorse in time, those would be mitigating factors. But the social workers' report of yesterday, examination in chief, cross-examination and re-examination, that's exactly what mitigation is about, to show that we can deviate from what stands based on these particular facts and based on this particular individual.
Yeah, Advocate Baloyi, thank you so much for your time.